It's great to be back here hosting. I'm hopeful that all of you are well. Welcome to summer. We can say that officially now. We are here. And in New York City, there is no doubt it is summer. We are experiencing record heat right now. It is 96 degrees in Midtown. And that's just the thermostat, the asphalt bouncing the sun rays off. Certainly warm things up even more. Tomorrow, it's going to be similarly hot. And later today, it's supposed to get up to 99. So maybe Phoenix and New York City are not so different after all. We are delighted, of course, though, to keep you focused on what's happening in the world that is relevant to all of you from the policy perspective, from the legal updates perspective, and we've got a full program ahead. And with that, Kathy, let me walk through the agenda, please, if you wouldn't mind advancing to the next slide. If you take a look at the top here, I'm going to tell you a little bit more about the legislative session that wrapped up officially. I know that you heard a little bit about it from Carrie last week. For those of you who tuned in, I will provide some more detail. We're also focused on primary elections here in New York State. Today is a big one for that, and they are happening all around the state. More on that, as well as what's going on with the Supreme Court, because it is the end of June and big decisions generally come our way around this time. So we'll briefly touch on that. After that, we'll have Michelle Hisecki, who is with us from the Albany office, a senior counsel we're delighted to have on the program for the first time, to provide an end of session spotlight on what we're familiarly calling the HEAT Act. It's a bill that actually ended up having a bit of a name change before it found its way through the legislature at the end of session. But it's a bill that deserves a deeper dive. It's about energy policy that certainly affects a number of you tuning in, and we thought it would be important for you to know what happened there. Alyssa Christian is with us. We are delighted, as always, to have Alyssa on the program from Syracuse. Alyssa's going to shift gears a little bit and talk about the do's and don'ts of doing business as arrangements. That is something that many of you in business practice think of as a kind of a straightforward affair. Sometimes it is, sometimes it's not. And then we're going to close out with Tom Huron, who has, of course, been on the program many times over since the beginning, and we're delighted to have the former chair of our labor practice back on the program. Tom was on just earlier this month, of course, and this time Tom is going to be talking about the end of session activity relating to the labor frontier, as it were, and we'll also be talking about changes in WARN notice protocols, which is not quite legislative, but legislative adjacent, and we thought it was worthy of your attention. I'll wrap things up by about 12:30, and in the interim, if you have any questions or concerns, as always, please enter them into the Q&A, and we will do our best to answer them. So with that, if you go to the next slide, please, Kathy, and one more after that, please. As you know, the session closed, and in a previous presentation that I gave to you, I walked through some of what was ultimately being decided on by the two houses, the Assembly and the Senate, and the fact that some bills get signed right away by the governor, others don't. In New York State, there's a process of delivering the bills to the governor, which can be either very lengthy or very short, depending on the strategy employed by those who are hoping to get the bill signed. But one of those that is certainly subject to strategy is medical aid and dying. It passed both houses. There are questions certainly stirring about whether the governor will sign it. I know that there's active effort underway right now to give the governor more information around that. Exactly the timing of when the bill will be delivered, et cetera, is an open question, but we'll keep all of you posted. If you look to the right of the slide in front of you, I took a quick snapshot from a legislative tracking system that we use. And what you see there are signings, just a small portion of them from, excuse me, not signings, let me stand corrected, bills that pass both houses, which is different, from June 17th to June 20th. And these are bills that are just listed in random order, as it were, that only represent a small fraction. The activity at the end of the legislative session was quite vigorous, even though the session was shorter than it normally would have been in function, because the budget was negotiated much later into the season than it has been in years past. So a lot of dust is settling, and we will continue to keep you apprised around, which bills actually make their way onto the governor for the governor's consideration and which ones won't. More on that again from my co-presenters today, Michelle and Tom in particular. The Grieving Families Act I had mentioned previously as well. That is something that has gotten the attention of the governor many years over. The governor has not been comfortable signing into law this, and maybe this will be the year we will find that out. All while that is happening, we are still contending with a very active federal legislature, which is working on reconciliation. The bill that we've talked about here, that would ultimately potentially lead to a return of the New York State legislature later in the fall to recast the budget if the changes in federal funding to New York State and others around the country is so significant as to require that. That's an open question whether that will happen. But the reconciliation process, which is what I'm talking about here, is very much ongoing and very much being hotly debated in Congress. The Senate introduced its version of the bill that it would wish to see passed, and the cuts and other activities around Medicaid as proposed are more significant there than in that House version. What that means for New York State, again, we have yet to see, but it could be, again, quite significant. So we know that there's a goal that President Trump and the leadership on the Republican side set for seeing passage of the reconciliation. July 4th is the date. Whether that indeed is met remains to be seen. There is active negotiation ongoing between the Senate and the House. What we don't yet know is whether bill language will change enough that will require essentially new bills and new, cleaning up, as it were, through the legislative process in Washington, which would then lengthen the overall process to get something before President Trump to consider. All of which is to say, July 4th is a maybe, not a definite, and we'll see. And as soon as we know more, we'll let all of you know. None of that is per se New York State, but it's certainly relevant to what happens in New York State. Next slide, please. And so just as I mentioned, there are bill signings happening. Here you have a snapshot of some of the bills that the governor has chosen to sign already in this end of session flurry. These are not in any particular order other than, it's just an example. Some of them are very modest in their scope. Some of them are much broader. As we dig into these item for item, we'll bring, details on some of them back to all of you as we deem them relevant, because of course, we recognize that some of these new laws will absolutely have effect on your businesses. There are others, though, that remain pending. If you look at the graphic on the right side of the slide, you'll see the Fostering Affordability and Integrity Through Reasonable Business Practices Act, or FAIR Act, which is just one example of a bill that has seen approval by both houses, but that the governor hasn't yet formally begun to consider. So the bills are in different positions, many of them yet to be ultimately reconciled. So we'll keep you all posted. Next slide, please. Let's move on to, as I mentioned, what's going on with the primaries. Here in New York City, we have a Democratic primary that's quite active. New York, of course, has many more registered Democrats than Republicans, so the Democratic primaries have often had very significant resonance relative to the general election. Put another way, who wins the primary often, really foretells what's going to be happening in the general. Whether that's true this year is very much an open question. Former Governor Cuomo is on the ballot, and the potential front runner. There are other candidates as well, including Mandani, who's receiving very significant attention. One of the interesting issues that we're seeing play out as we have this highly intense heat today. The question is whether it will detract from those turning out to the polls. We have early voting now in New York State, and from what has been reported, there have been many more folks who have gone to vote early than has been historically the case. Many of them are also younger voters, not necessarily in the core of those that the former governor is counting on in terms of turning out. So today will be an important day for those that have voiced a connection to the former governor and are interested in voting for him. We also have ranked choice voting here in New York City, where essentially rather than voting for one individual, you vote for individuals in priority order, and there are runoffs that may or may not take place depending on how close all of this plays out. We will not know all the answers on what's happening in New York City for a bit of time, in part because the intense heat has led to some issues at polling sites with electricity reliability. So the certitude of getting all the data back by tonight is broadly uncertain, but we'll have more on that as we learn more. Of course, it's not just New York City where activity is happening. There's a new mayor being considered, at least through the primary process, in Syracuse. We also know that general elections may well be where a lot of this leadership is ultimately determined. The current mayor, Eric Adams, here in New York City, for instance, did not run in the Democratic primary and is choosing, by way of the nature of the current campaign, to run as a candidate only in the general. We shall see how this all plays out over the coming months. Just note to all of you to stay tuned. Finally, and I want to turn this over to additional speakers in just a moment. The Supreme Court is wrapping up its calendar. We have expectation that on the 26th, certainly, there'll be at least one or two decisions that will come through and will be the subject of scrutiny all across the country. Exactly what happens has yet to be determined, and we will, as we often do here on the webinar, make sure that we scrub those decisions and review them once they are shared with all of us in the public, so that we can figure out how they apply to your businesses and otherwise your priorities. So more to come on that certainly in July and thereafter. But with that, let me turn to our next speaker, who I mentioned is Michelle Pasicki, who is with us from the Albany office, senior counsel, who has a focus in legal practice on energy policy. And we thought it would make sense collectively for Michelle to talk about some of the energy legislation and its potential impacts on all of you. So Michelle, welcome to the program. We hope this is one of many appearances you'll be making, and we're glad to hear from you.
Thanks very much. Delighted to be here. So the HEAT Act is the Home Energy Affordability Act. As Gabe alluded to, it was formerly known as the Customer Savings and Reliability Act. It's really an attempted effectuation of the Climate Leadership and Community Protection Act that was passed in 2019 in terms of a plan to transition away from natural gas use within New York. So the CLCPA requires that 70% of the state's energy come from electric resources by 2030, 100% zero emissions by 2040, 40% reduction in greenhouse gas emissions by 2030, and then an 85% reduction of greenhouse gas emissions by 2050, and then net zero emissions by 2050 as well. So really trying to attempt to move the main fuel source within the state away from natural gas into other more renewable resources. So this HEAT Act has a couple of aspects of it, that legislatures were pursuing and pushing to try and get us more towards those goals. Some of those were ensuring energy affordability for low and moderate income customers. So the act attempts to restrict customers' energy burden to 6% of their household income for those customers and ensuring that they're, not having to fund beyond a certain cap of their income, what they're paying for certain energy programs within the state. It's requiring both the Public Service Commission and utilities to come up with plans to move away from natural gas. So the PSC would be required to create a statewide affordable gas transition plan. And as part of that plan, utilities would be required to come up with their own home affordable transition plans, which would allow for more renewable and or flexible utility options beyond just natural gas, because the law itself, the public service law, requires utilities to provide more natural gas currently. And if a new residential or non-residential customer wants to receive service, the utilities flexibility to deny them natural gas service and provide them with some other form of service is limited. You could have a customer, you could have an entire community who wants to transition to thermal energy, but if one customer isn't on board with that transition, then it can effectively stop the entire community from doing so. So that the proposed changes within the act would allow for the utilities to kind of roll out these transition plans and have more flexibility to create these, kind of discrete energy sourced communities that would not be reliant on natural gas. And it also would prohibit the what's known as the 100-foot rule. So any new home or new building that's within 100 feet of a utility main service line is required to be hooked up if they're seeking natural gas service, and the cost of that is not borne by the customer. It's borne collectively by ratepayers across the state. And that cost amounts to about $200 million per year. So seeking to end that requirement for that hookup and push the cost of any new service onto the actual customer who's seeking to hook up natural gas is something that the act requires as well. The HEAT Act was not adopted in full in this last legislative session, so it's something that's probably going to come up in the future as some of the supporters for the act are likely going to want to pursue these full items that were on the agenda. But the 100-foot rule was adopted, so utilities are now no longer required to transition new service for customers and take that cost and make the rest of the ratepayers pay for it. It's now going to be incumbent upon who the new user is to pay for those costs. So that will, like I mentioned, that will see a savings of about $200 million for ratepayers collectively, according to proponents of the bill across the state. I think that's all I have on the act for now.
Well, thank you so much, Michelle. That was a terrific update, and we're really glad that you could take the time to provide it. And please keep us posted on movements in the legislature. As you noted, didn't quite get over the line this session, but we'll see what happens. And I know that the conversation will remain active on these issues in New York State. Let's turn to Alyssa, who is with us from Syracuse. And Alyssa, shifting gears a bit, is going to talk about DBAs. Alyssa, thank you for coming back on the program, and please take it away.
Hi, everyone. I'm going to take a few minutes and go over when an assumed name, aka a DBA, is needed. Recently, there have been some states that have taken efforts to modernize their registration processes, so I thought this was a good time to give this basic overview. Sorry about that. So on this slide, I have listed out a few different terms that are often confused, used interchangeably. I'm hesitating to say used incorrectly because these terms are, their definitions seem to vary state by state and even within the context of what we're talking about. So hopefully by going over them, I'm going to give you some clarity on what they are and how a DBA could be beneficial to your business. The first term I have listed here is a legal name, which is referring to the actual name of a business. And so if this is a entity, it would be what is on its organizational documents. A legal name is also known as a true name, a real name, an actual name. The second term I have listed here is a trade name. And to be clear, a trade name could encompass a legal name, but the purpose of a trade name is to identify the source or distinguish the business from other providers. Next, I have listed assumed name, which is what we're talking about here today. In New York, a DBA is officially called an assumed name. And that's really just any name a business is operating under that is not its legal name or true name. And lastly, I have listed a fictitious name, which in many states refers to when a business has to adopt a new name to qualify to do business in that state, just to be able to conform to that state's naming requirements. So on this slide, I have some considerations. Actually, we're going to go back one, sorry. I'm going to talk about when a DBA is needed and when it's not. So again, as I've mentioned before, a DBA is needed whenever a business is operating under anything other than its legal name. And so that means to comply with the law, it needs to be registered or filed within the state. In some states, they do it county by county. This, by registering an assumed name, you're putting the public on notice with who they're actually dealing with. So this is really a consumer protection law. And because it's consumer protection law, it's not actually doing very much for intellectual property rights. And that's a big misconception. It's not necessarily preventing others from using the name. And I also want to point out that it does not create a legal entity. Anybody can file a DBA. You do not have to be a business entity. So sole proprietors need to file a DBA if they want to do business under anything other than their name. And then lastly, I also want to point out that you can have more than one DBA, so businesses can have many. And in some states, the state will allow numerous businesses to have the same DBA. So that could be good if you have numerous business entities and they all want to operate under one group DBA, but also not so great if there's another business that's using your DBA. So when to consider adopting an assumed name. Again, if you are using anything other than your real name, you need to formally adopt this assumed name by filing or registering it within the state. You might want to consider one if you are looking at a new rebrand. An assumed name adoption is a much cheaper option to just test out a name, because again, if you're going to be using the name to see how it is with consumers, get a new target audience, you need to be registering that name, but it's a lot cheaper than actually changing the name of your business or, going through a whole rebrand. Franchises often have to use assumed names because there's a business entity that is a generic name, but they want to actually do business under their franchisor's name. And then lastly, if you're looking to divide your business into different brands or a different target audience, a DBA will allow you to use a different name and maybe get a new segment of the market. And then just some brief considerations. As I said, a DBA could be very helpful, but it also might just be easier to do a new entity or rename the entity. And also point out that if you are using a brand name in conjunction with your legal name, you may not actually be considered doing business under a different name because you're still using the real name. Therefore, you wouldn't need to register the DBA, but that can be a bit of a legal analysis. So please take that advice with a bit of caution. And then again, DBAs don't provide much IP protection, and it's always smart to make sure that you're protecting and building your brand name. So you want to consider some trademark adoption and registration as well. And then finally, DBAs, they are cheaper than the alternative of changing the name, but it might just be easier in some situations. So again, if you think a DBA might be beneficial, there are some things for you to consider, and I encourage you to reach out to make sure you choose an option that is, legally and beneficial to you.
Alyssa, that is great and really helpful. It's one of those issues that folks might not have been thinking as much about as perhaps they should have been. And as you noted, Alyssa, you're available to dive more deeply. So again, appreciate that and all your contributions to the webinar. Let's turn to our final speaker for today's program, and that's Tom Iran. We're thrilled to have Tom with us once more. As noted, Tom is the former chair of our labor practice and a regular contributor to the webinar, indeed one of its founders. And we are thrilled that Tom is here to talk about the legislative session. We're going back into that deep dive modality with plenty of activity in the labor space that Tom's going to highlight for ultimately all of your benefits, so that from the various long lists of actions, you can really think about what's truly important to your businesses. So Tom, please take it away, and thank you so much.
Thanks, Gabe. Good afternoon, everyone. Kathy, if we could go to the first slide. So one of the most significant bills that we were tracking this session was on potential increases to the short-term disability provisions in the workers' compensation law, in particular because the legislation had such a significant potential increase. The current maximum under the state required short-term disability is only $170 a week. And the proposal was to move this consistent with the Paid Family Leave Act to 67% of someone's earnings, which, as an estimate is $1,100 a week. So a major increase, major cost increase for employers. However, this bill did not get through the legislature. I think there's generally a sense that something needs to be done, but this was more than the Assembly and Senate were willing to swallow this term. So I think we'll see it again next year. So Kathy, if we could go to the next slide. A real interesting development which did pass the legislature dovetails with a topic that I've talked to on this webinar many times, and that's national labor relations issues. Just as a recap, the current National Labor Relations Board is non-functional. There are 2 members, and 3 are required for a quorum for it to take any action. There is no nominee proposed for any of the 3 openings. And so the status quo at the Labor Board, at the National Labor Relations Board, is inaction. New York State Legislature steps in and amends the New York Labor Relations Act. Now, this is a bill that we hardly ever talk about. It only applies currently to private sector businesses that are too small, that don't meet the jurisdictional requirements of the National Labor Relations Act. And so it has very little currency to businesses in New York. But it exists, and it has its own set of rules in terms of union representation and unfair labor practices. What the legislature has done, and if we could go to the next slide, it has passed a bill. This is now passed by the legislature. It has not been signed into law yet. We'll talk about that in a minute. But this bill would change the exclusion in the current New York State Labor Relations Act. Currently, all matters that are subject to the jurisdiction of the NLRB are excluded from New York State law. The new language is only if the NLRB has asserted jurisdiction, actually effectively, actively asserted jurisdiction over a particular employer, is it excluded? And there's this language about pursuant to a federal court order, which to me is a non sequitur, because the NLRB asserts jurisdiction. It doesn't need a separate federal court order to establish jurisdiction. But in any event, what the legislation does is it says, if the NLRB does not actively take jurisdiction, the parties can go to the state labor board and request verification of the union as a representative, even if the union has already been certified by the National Labor Relations. So it's essentially allowing unions to fill the gap here, go to the New York Labor Board, establish its status as the exclusive representative of the particular bargaining unit, and create jurisdiction at the New York State level under the New York State Labor Relations Act over relationships that have previously existed under the National Labor Relations Act. So the legislature would allow the New York Labor Relations Board to step in where the National Labor Relations Board has become inactive. And the statute also provides, or the legislation also provides, it's not a statute yet, that during this process, employers would be prohibited from changing terms and conditions of employment. A fairly radical piece of legislation intended to, as I say, fill the gap from the inactivity of the National Labor Relations Board. So if we could go to the next slide. And this echoes some of Gabe's points earlier. It's passed the legislature. The next step is for the legislature to submit it to the governor. As of this morning, that had not happened. And as Gabe mentioned, there's a little bit of a strategy associated with that step in the process. To my knowledge, and in fact, a client just asked me about this earlier today, we don't have a read on whether the governor is in favor of this legislation. And again, that's fairly typical. There will be an internal review and certain politicking about this development and whether it makes sense. And because the legislature is controlled by the Democratic Party, the timing of the submission of the legislation to the governor will be coordinated. And my best guess is this will be held for a while as the state considers what the Trump administration does on a national level with the National Labor Relations Board. Do they move forward with appointments and reinvigorating that board? And if not, it then goes before the governor, and we'll see whether or not she signs it. Assuming she signs it, and assuming some union decides to seek verification and jurisdiction under the New York law, you can guarantee that there will be challenges, mostly, obviously, on a federal preemption grounds, right? The concept of the National Labor Relations Act is that labor policy is set at a national level, and it preempts any state law that interferes with what the national standards are. So I would anticipate if this law is enacted, there will be significant litigation over whether or not it is a proper exercise of the state's authority. But let's stay tuned on that one. The other issue that I wanted to talk about, and Kathy, if you could flip to the next slide. There was a news report last week that of legislation amending the New York State WARN Act dealing with artificial intelligence. And we tracked this down. There is no legislation. That was a bit of a misnomer in the news report. But what has happened is, and this was an initiative from the governor, it did make a change to the regulatory process for warrant reporting. And as you likely know, in New York State, there's a 90-day notice requirement in the event of a plant closing or mass layoff, and that notice has to go to employees. If there's a union, it goes to the union, local government officials, and to New York State. The reporting to New York State now includes a AI component. And if we go to the next slide, we can walk through what that is. So if you're reporting a warrant event, you do it through a portal, an online portal. And now the questions that the employer are asked include this question: is the layoff due to technological innovation or automation? The answer to that is yes. There's a drill down menu on factors that might have led to that technological change, including artificial intelligence. And if you answer yes, artificial intelligence was a component, then you have to provide a further explanation to the state. No clear understanding of what the state is doing with this information, but they are extracting it from those employers who suffer a warrant event and need to report it to the state. Again, as these matters develop, we'll keep you apprised. Those are the key items that I wanted to share with the clients and audience today. Abe, I turn it back over to you.
Tom, thank you as always. That was very helpful. And as some of these issues percolate over the course of the summer, including the potential bill signings, Tom, please make a point of coming back onto the program. We would love to learn more. In the meanwhile, knowing that we're a few minutes past 12:30, let me briefly ask all of you to take a look at this slide. Thank you, Kathy. That summarizes where you can find us via email. You can always just reach out to me if you have any questions, and I'll get you to the right place. In a week's time, Carrie will be back as your host as we move into July and the summer all the more deeply. We thank you very much for your continuing commitment to the program, and we look forward to bringing you further content as we move into the next month on the calendar. In the meanwhile, have a terrific afternoon and stay cool and safe out there.